favorably. Motion for Taylor B. McNeil to be United States District Judge for Southern District of Mississippi. Favorably to the floor. The clerk will call the roll.
Mr. Grassley.
Aye.
Mr. Cornyn.
Aye.
Mr. Lee.
Aye.
Mr. Cruz. Mr. Sass. Mr. Hawley. Mr. Tillis. Ms. Ernst. Mr. Crapo. Mr. Kennedy. Mrs. Blackburn. Mrs. Feinstein. Mr. Leahy. Mr. Durbin. Mr. Whitehouse. Ms. Klobuchar. Mr. Coons. Mr. Blumenthal. Ms. Hirono. Mr. Booker. Ms. Harris. Mr. Chairman.
Aye.
Mr. Chairman, the votes are 12 yeas and 10 not present.
The reported favorably to the floor. Next, Catherine Mizell to the United States District Judge for the Middle District of Florida. Favorably to the floor. The clerk will call the roll.
Mr. Grassley.
Aye.
Mr. Cornyn.
Aye.
Mr. Lee.
Aye.
Mr. Cruz. Mr. Sass. Mr. Hawley. Mr. Tillis. Ms. Ernst. Mr. Crapo. Mr. Kennedy. Mrs. Blackburn. Mrs. Feinstein. Mr. Leahy. Mr. Durbin. Mr. Whitehouse. Ms. Klobuchar. Mr. Coons. Mr. Blumenthal. Ms. Hirono. Mr. Booker. Ms. Harris. Mr. Chairman.
Aye.
Mr. Chairman, the votes are 12 yeas and 10 not present.
Nomination of Thompson Dietz to the United States District Judge for, to be United States District Judge for the United States Court of Federal Claims. Favorably to the floor. The clerk will call the roll.
Mr. Grassley.
Aye.
Mr. Cornyn.
Aye.
Mr. Lee.
Aye.
Mr. Cruz. Mr. Sass. Mr. Hawley. Mr. Tillis. Ms. Ernst. Mr. Crapo. Mr. Kennedy. Mrs. Blackburn. Mrs. Feinstein. Mr. Leahy. Mr. Durbin. Mr. Whitehouse. Ms. Klobuchar. Mr. Coons. Mr. Blumenthal. Ms. Hirono. Mr. Booker. Ms. Harris. Mr. Chairman.
Aye.
Mr. Chairman, the votes are 12 yeas and 10 not present.
The nomination will be reported favorably to the floor. Now we have a subpoena request. I've been asked by my Democratic colleagues to hold it over, and I think there's a lot of interest on the other side of getting some of the social media folks here to answer questions about their platforms. So I'm going to move forward with the request today for the subpoena, hopefully give us some leverage to secure their testimony. I move to vote on the chairman's October 22nd, 2020 motion to authorize subpoenas to Mark Zuckerberg and Jack Dorsey relating to online content modernization. The clerk will call the roll.
Mr. Grassley.
Aye.
Mr. Cornyn.
Aye.
Mr. Lee.
Aye.
Mr. Cruz. Mr. Sass. Mr. Hawley. Mr. Tillis. Ms. Ernst. Mr. Crapo. Mr. Kennedy. Mrs. Blackburn. Mrs. Feinstein. Mr. Leahy. Mr. Durbin. Mr. Whitehouse. Ms. Klobuchar. Mr. Coons. Mr. Blumenthal. Ms. Hirono. Mr. Booker. Ms. Harris. Mr. Chairman.
Aye.
Mr. Chairman, the votes are 12 yeas and 10 not present.
Motion is passed. Thank you. All right. Thank you all. I'll be glad to listen to any comments you'd like to make. But we did it. We did it. Judge Barrett's going to the floor. I hope you look back on this time on the committee and say, I was there when it mattered, and you were. Senator Lee.
Thank you, Mr. Chairman. It is indeed an honor to be here on this historic occasion when we've confirmed Judge Barrett and forwarded favorably to the floor our recommendation. As I've said ever since she was nominated to this position, Judge Amy Coney Barrett is one of the most impressive legal minds in the United States. She's a thoughtful and fair-minded lawyer, a loving daughter, wife, and mother, and a devout believer in her faith and in the Constitution. She was arguably the most impressive judicial nominee that I've ever seen in any of these hearings. And I've been watching them intently since I was a kid. Judge Barrett is going to make an absolutely outstanding Supreme Court justice, and the American people will have her on the bench. It is a shame that our colleagues on the other side, having failed to lay a glove on Judge Barrett during the hearings, have chosen to walk out on this process, and in so doing, walk out on the American people. This is sad, but in context, it's not really that surprising. I suppose we should be grateful that a walkout is all the Democrats will do to Judge Barrett today. Not all nominees have been so lucky. This is an important point for those watching these proceedings who might be tempted to believe the pious pearl-clutching and performance art of the media and the minority party about this particular nomination. I'd like to take a few moments to set the record straight about the history of this process and why America needs and deserves to have Judge Barrett on the Supreme Court. For the first 200 years of the history of our republic, Supreme Court nominations of both political parties were almost always polite and even boring, relatively nonpartisan, non-political affairs. Judicial nominees were examined for their qualifications and rejected by the Senate only in relatively rare instances. But that era of generally common mutual respect ended in 1987 when a Democratic-controlled Senate shamefully and slanderously defeated the nomination of one of the country's most respected lawyers and constitutional scholars. That is Judge Robert Bork. The cynical attacks against Judge Bork, whose only offense was that he was a conservative, were dirty, and they were downright dishonest. But like the boy who cried wolf, Senate Democrats got away with it, at least the first time. 4 years later, President George Herbert Walker Bush nominated Judge Clarence Thomas, then serving on the U.S. Court of Appeals for the D.C. Circuit, to replace Justice Thurgood Marshall. Democrats on the Judiciary Committee, Democrats, not Republicans, tried to do to Judge Thomas what they had done to Judge Bork a few years earlier. The public was now wise to the Democrats' game, and that particular attack, while injurious, failed. So they resorted to the next tactic, organizing what Thomas rightly called a high-tech lynching of a black man who dared disagree with the rich white liberals who ran the Democratic Party. When Democrats won back the White House in 1992, when the shoe was put on the other foot, Senate Republicans did not retaliate. Senate Republicans did not respond the way they did. They did not respond in kind. In 1993, the famously liberal Judge Ruth Bader Ginsburg was confirmed to the Supreme Court with 96 votes. In 1984, Judge Stephen Breyer was confirmed with 87 votes. They went low, and in response, we went high. Now, did Republicans' good faith behavior influence or improve the Democrats' behavior? No. The record suggests that it only encouraged them. Within a decade, Democrats once again breached norms. They unilaterally escalated their war over the judiciary by filibustering, for the first time in history, a judicial nominee, Miguel Estrada. Mr. Estrada was, and remains to this day, one of the most respected lawyers and constitutional scholars in the country. He was a natural and inspiring choice to serve as a federal appellate judge. But to the left, you see, that was precisely the problem. Mr. Estrada was Latino and brilliant and charismatic and young and widely seen as a future nominee to the U.S. Supreme Court. So the left decided to strangle Mr. Estrada's nomination with false, insincere attacks and unprecedented obstructionism. They filibustered Mr. Estrada's nomination. Not once, not twice, but 7 times. Fan service to hateful leftist groups who were vilifying an honorable man in a revolting tantrum of political cynicism and blatant racial condescension. Sure, during this ordeal, Mr. Estrada's family suffered irreparable tragedy, but at least the New York Times was happy. And the left sent a clear message to Latino Americans about what they can expect if they, too, dare question liberal orthodoxy. Thus, Democrats ushered in yet another new era in their, not the, but in their judicial culture wars, the era of judicial filibusters. Now remember, at the time of the Miguel Estrada filibuster, Republicans had control of the White House and of the Senate. They could have invoked the nuclear option to break the Democrats' unprecedented norm-breaking obstruction. We didn't. We did not retaliate, not after the Estrada filibuster, not after the Democrats' malignant, mendacious smearing of then-Judge Sam Alito on his way to the Supreme Court. It's not the narrative, but it is the truth. Once again, Democrats went low, cruelly, disgustingly low. And once again, Republicans took the high road. Under President Obama, Republicans accepted the Democrats' practice and required supermajority cloture votes for judicial nominees. After a few years of this, Democrats got tired of having to play by their own rules, so they broke them. In 2013, with a number of Obama policies being challenged on constitutional and other grounds in the courts, Democrats invoked the nuclear option over Senate rules so that they could confirm judges with only 51 votes. Republicans pleaded with Democratic leader Harry Reid not to do it, and we warned Democrats that they would soon live to regret it. But hubris makes the powerful deaf as well as blind. They rammed through their appellate court judges. We could not stop them. They did it because they could. In response, the American people did what they could. In the next election, and in fact, in every single congressional election since the Democrats went nuclear in 2013, the American people returned a Republican majority to the Senate. That included the election of 2014, which meant that when President Obama appointed Judge Merrick Garland to replace the late Justice Antonin Scalia, the Senate, following precedent established by Democrats decades earlier, rejected that nomination. That included the election of 2016, when Donald Trump was elected president. When he selected Judge Neil Gorsuch to replace Justice Antonin Scalia, Democrats once again filibustered and then feigned outrage as Republicans followed Democrats' precedent again and triggered the nuclear option on Supreme Court nominations. Now, let me go on record. I initially had concerns about this move. In conference meetings for some time, I argued to my colleagues that we ought to at least try to find another way, try to see if we could figure out a way to restore the judicial filibuster and simultaneously preserve this important part of the Senate's institutional design and of presidential prerogative. I lost that argument. My position may have been principled, but in the context of the Democrats' relentless and endless pattern and practice of abusing their power, it was untenable. I tried to persuade my colleagues to seek a good faith bipartisan solution. The problem was that was not. The only precedents Democrats had given us to work with were Bork, Thomas, Estrada, and the nuclear option. My colleagues pointed out the obvious. Democrats' embrace of judicial power and of judicial total war was not a slide down a slippery slope. It was a giddy, enthusiastic leap that they still don't regret. Just look at the record since then. In 2018, when Justice Anthony Kennedy retired and President Trump nominated Judge Brett Kavanaugh to replace him, was there any sign, any evidence whatsoever of an intent to lower the temperature? Any indication that Democrats were rethinking their decades of vicious, unilateral escalation? Just as before, of course not. During the Kavanaugh nomination, they stooped to new lows, concocting a patently false accusation of teenage sexual assault against an honest, honorable, and innocent man. Nominations of constitutionalist judges is simply what the left does. This is a feature, not a bug. This is how they operate. This is what they do. Liberals, not conservatives, turned the Supreme Court of the United States into a super legislature of sorts. Democrats, not Republicans, escalated Supreme Court confirmations into ideological knife fights and worse, and made political outcomes the defining issue of this process rather than judicial philosophy and qualifications. What has happened to this problem isn't a bipartisan failure. It is a unipartisan strategy. Every norm broken, every act of escalation, one party, the Democrats, has been the aggressor in every single instance. At every step along the way, our side has used our constitutional authority, and the other side has abused its authority. There is no tit for tat, there's just tat. Democrats killed Judge Bork's nomination for partisan political reasons. They killed Miguel Estrada's nomination for partisan political reasons. They slandered Justice Thomas, Justice Alito, and Justice Kavanaugh for partisan political reasons. They nuked the filibuster, again, for partisan political reasons. And now they're trying to scuttle this meeting, this hearing, this vote for partisan political reasons. When it comes to the judiciary, abuse of power is their agenda. Now, the left seems to think that the Supreme Court exists for this purpose and that it exists to impose their very worst ideas onto the public, onto those recalcitrant members of the public, those people we call citizens who refuse blindly to go along with their entitled extremism. They want the court to empower abortion activists and woke performance artists, campus and corporate elites, and social media outrage addicts to tell everyone how to live without votes, without accountability, and without debate. Taking debatable matters and placing them beyond debate seems to be their formula. They don't want democracy. They don't want representative government. They want docility. And Judge Amy Coney Barrett is not going to give it to them. She's not going to politicize the Supreme Court. She's going to help depoliticize a court that the left has spent decades turning into an extra-constitutional Sanhedrin of philosopher kings. She's going to turn back policy decisions and political debates back to the people and their elected accountable representatives, where they properly belong. Judge Barrett understands that under our Constitution, policy is supposed to be determined by the priorities of the people, not editorial boards or Twitter trolls or safety school faculty senates. That is why the left is so furious about this nomination. For all the pious pablum you hear on MSNBC, and for all the pious pablum you'll hear on MSNBC and those other networks tonight, understand they aren't angry because this process isn't fair. They're angry because it is. Not because they think Amy Coney Barrett is going to be a partisan justice, but because they know she will not be. They're not afraid Judge Barrett will legislate from the bench, but that she will force Democrats and Republicans to legislate from legislatures, as the Constitution itself requires. Judge Barrett threatens their power, not because she has a hidden agenda or hidden powers, but because they do, and she won't enact those powers or exercise them by judicial fiat. And that is exactly why we need to have Amy Coney Barrett on the Supreme Court of the United States. Not to avenge Bork, Thomas, Estrada, Alito, or Kavanaugh, but rather to restore the institutional integrity of the Supreme Court and to the Senate and all the public institutions that leftist judicial abuse has twisted and desecrated for 2 generations. We need to confirm Amy Coney Barrett, not to give political power to conservatives or Republicans, but to finally give it back to the American people, from whom it was stolen so many years ago. The left has taken the political low road on the judiciary for decades. Amy Coney Barrett will take the constitutional high road for decades to come, every day earning, in more ways than one, her new title of justice. Thank you, Mr. Chairman.
Thank you. Well said, Senator Lee. And I have a full statement I'll introduce into the record without objection about the process. I think Senator Grassley would like to speak for about 5 minutes. Is that correct?
I hope it won't irritate you, Mr. Chairman,
It will.
if
Music to my
I
ears.
take a few minutes.
Take your time. Senator Grassley.
Obviously, our colleagues don't think that they ought to represent their states by, and that's what they're not doing, is representing their people when they don't show up here. I'm talking about my colleagues across the aisle. But those of us that are here are pleased to have voted Judge Amy Barrett's nomination out of committee to the floor. And the reason for doing that is that she has the temperament and humility that we would expect of a judge. She approaches cases without bias and agenda. Most importantly, she understands that a judge should interpret, not make the law. She was thorough, candid, and forthright in the hearing, but when pressed on how she might rule in a case, Judge Barrett properly applied the Ginsburg rule, and that rule demonstrates her independence by not showing any hints, previews, or forecasts. And those 3 words are from the Ginsburg testimony of about 28 years ago. Judge Barrett clearly respects precedent, and she practices judicial restraint. Her judicial method is rigorous and exacting, but fair and open-minded. I specifically asked Judge Barrett if she had made any promise to anyone about how she might rule on a case. She responded, "The answer is no." Quote, "The answer is no. It would be inconsistent with judicial independence." End of quote. She just expressed there what we expect and learn from 8th grade civics, what the checks and balances of government are all about. The Supreme Court is the court where we expect them to make sure that the executive branch and the legislative branch doesn't go outside the bounds that the Constitution sets for this Congress and the executive branch. Judge Barrett, out of committee, to be an Associate Justice of the Supreme Court. Thank you, Mr. Chairman.
Thank you, Senator Grassley. Senator Hawley would like to present a statement for the record, and that will be allowed without objection. Senator Cruz.
Thank you, Mr. Chairman. I want to commend you, Mr. Chairman, on conducting a remarkable set of hearings last week. And I want to commend every member of this committee for the result, approving Judge Barrett's nomination, moving it to the floor, where I have every confidence she will be confirmed on Monday. This is a major victory for the American people. This is, in many ways, the single most important accomplishment President Trump has achieved in office. In nominating a principled constitutionalist to the Supreme Court, President Trump was honoring the promises he made to the American people. And in confirming that principled constitutionalist to the court, the Republican majority in this Senate will likewise be honoring the promises that we made to the American people. I want to take a moment to highlight something that we've learned in the last 2 weeks, which is that the Democrats understand that their radical agenda for the Supreme Court is profoundly unpopular. The Democrats are unwilling to defend their radical agenda for the Supreme Court. That's illustrated powerfully today by the fact that every Democratic chair is empty, that they are boycotting this markup. They're boycotting this markup because their substantive arguments are not persuasive. They're not effective. Last week during the hearing, it was striking. Not a single Democrat asked any questions that defended the far left's view of religious liberty, which is that the Supreme Court should go through the public square, scour the public square to remove any reference to God Almighty. Not a single Democrat defended the far left's radical view of religious liberty, that the government has the power to punish you for living out your faith. I noticed these lovely photographs in the place where our Democratic colleagues normally would be. You know, one photograph I don't see is a photograph of the Little Sisters of the Poor. The Little Sisters of the Poor, a Catholic convent of nuns who've taken a vow of poverty, who the Obama administration persecuted because they were living according to their religious faith, and who Joe Biden pledges to once again persecute if he is elected. Not a single Democrat in this committee defended that radical view of religious liberty because the American people don't want it. They want a court. A Democrat during the hearing last week defended the Democrats' radical view of free speech, which is that the federal government has the authority to regulate political speech, to regulate your free speech, and to silence you if you dare criticize a politician. That is a terrifying increase in government power. There have been 4 votes on the left for that proposition, that the federal government has the power to ban movies, that the federal government has the power to ban books. That was the position of the 4 dissenters in Citizens United, and not a single Democrat would defend that radical proposition because the American people have no interest in a federal government that has the power to regulate free speech. On the Second Amendment, not a single Democrat defended the proposition that 4 dissenters in Heller versus District of Columbia maintained, which is that the Second Amendment protects no individual right to keep and bear arms whatsoever, which means that government can make it a crime, a felony for any American to own a firearm, and there's nothing you can do to challenge it in court. There are 4 votes for that, 1 vote away. Not a one of them defends that radical proposition. And so I would say to all of us in the majority, we should take solace from this. They know the propositions they're advancing are radical, they are extreme, they're not what the American people want. To all of the grassroots activists who are out there fighting right now, less than 2 weeks away from Election Day, fighting to defend the Constitution and Bill of Rights, take solace in the fact that our absent Democrats understand last week was not going well for them. They tried to ask a few questions of Judge Barrett, and they realized this ain't good. The American people seeing this smart, calm, talented, principled jurist pledging to defend the Constitution, that is a problem for us, the Democrats. And by day 2 of the questioning, they had gotten out of Dodge. By midday, there were only 2 Democrats even left in the hearing room. Now, of course, 2 Democrats is more than we have here today. So it went from barely being present to being totally absent. There's a reason why Joe Biden and Kamala Harris refused to answer the question whether they intend to pack the court, because the answer is yes. If they get power, they will move to pack the court, to expand the number of justices, to fill it with partisans, an abuse of power that would do immense damage to the independence of the judiciary. And why won't they answer the question? Because they know it is profoundly unpopular. They know the American people don't want to see the court politicized, its independence destroyed, which is what today's Senate Democrats are pushing. The stakes of this confirmation and the stakes of this election coming up in 2 weeks are enormous. The reason the Democrats want to see leftists on the court is so that a majority of judges, unelected lawyers in robes, can mandate policy outcomes that the American people don't want, that they would never vote for, without our colleagues having to take responsibility for it. There are times when it seems Republican senators don't necessarily understand that the principles we're fighting for, the overwhelming majority of the American people are with us. But you know who understands that very well? The Senate Democrats who refuse to attend today. Congratulations, Mr. Chairman.
Thank you, Senator Cruz, for your participation in this hearing process. You bring a lot to the table for the conservative point of view and actually understand the process as well as anybody I've ever met. And thank you, Senator Lee, for reminding us how we got here. We got here through a tortured tale of abusing people, of trying to get outcomes, changing the rules to accommodate political desires, and it's ended today. I would love to go back to the traditional Senate approach of having to grab some people on the other side of the aisle to confirm a judge, but that was abandoned in 2013 for a purpose, to stack the D.C. Court of Appeals. That's where all litigation involving the federal government goes. And Senator Schumer and Senator Reid, to his credit, says, I did it, I'd do it again, and we should change the legislative filibuster. That's where Senator Harry Reid's at. I'm hoping that this election, people will listen to what Senator Cruz just said. We are 1 vote away from fundamentally changing the Second Amendment, changing how free speech works in this country, and on and on and on. So when they changed the rules in 2013 and filibustered Justice Gorsuch, requiring us to change the rules, it set in motion some things that I've worried about for a long time. But here's some good news. The Judiciary Committee got it right when it came to Judge Barrett. We did the right thing. It would have been wrong to deny her a vote. In my view, if you're a Republican, it would have been crazy not to vote for her. As a Democrat, you may not agree with her judicial philosophy, which is rejection of judicial activism and a originalist point of view of how you approach case and controversies, but you should have seen in her what I saw in Sotomayor and Kagan, qualifications. You've abandoned that. You expected me to impose the qualification test on Sotomayor and Kagan, and I did. It used not be this way. Justice Scalia got like 96 votes. Justice Ginsburg got 96 or 97. Senator Thurmond, my predecessor, voted for Ginsburg because she was qualified. Senator Hollings, a Democratic senator from South Carolina, voted for Scalia because he was qualified. What the hell happened? It wasn't us. Senator Lee made a very compelling case that it changed. It began, I think, with Bork, continued with Thomas, Alito, and it crescendoed with Kavanaugh. And I want to thank my Democratic colleagues who did participate in the hearing so you could ask her hard questions and suggest that she would not be open-minded. I think you lost that debate, but you did show up to ask her questions. You should be here to vote. She deserves a vote, yes or no. If you vote no, then you're solidifying the idea that qualifications no longer matter. If you vote yes, I don't know if you could still stay in the Democratic Party. I'm still here. I voted for Sotomayor and Kagan. I'm doing fine. It's just a shame that we've allowed it to get to where we have. It's a shame that my colleague, Senator Feinstein, who opposed the process and opposed the nomination, had a moment of human interaction, which apparently is it's not enough to agree with the cause. You got to hate the people they want you to hate. Boy, America is in for a real tough ride if it's not enough to agree with the underlying cause. You must hate to be really a legitimate liberal. It's not enough that you embrace the cause, but you have to hate. I hope that doesn't come on our side, because then we'll be reduced to hating each other rather than debating each other. It won't be about our ideas. It'll be about the fact that we just oppose the concept of each other. So I want to end this on a positive note. President Trump had a list that was vetted, and he picked Judge Barrett out of a list of really qualified people. As Senator Cruz said, I think maybe it's his most important decision. And this will be a historic moment. It's historic for young conservative women, knowing that there's a place at the table for you. I think it's a historic moment for the court to have somebody like Judge Barrett on the court who openly embraces their faith and has lived a consequential life. America is for all of us, African American and people of color who embrace Republican ideas and conservatism. They have a tough time of it in modern society. Same for women. So this is a breakthrough moment. I regret that we could not do it the normal way, but what I don't regret is reporting her out of committee. I could not have lived with myself knowing someone this qualified who worked this hard all their life to be a good, decent person is a giant when it comes to understanding the law, has the disposition that all of us would yearn for in a judge. I could not have lived with myself if I denied her her day. This is a culmination of a well-lived life. There's one more step in the process. That's the floor of the United States Senate. So whatever you think about Republicans or Democrats, and I know we're very divided, I hope you'll remember this was about Judge Barrett. This was about her and her qualifications. Was she worthy of the nomination? Did she conduct herself in a manner to be worthy of our votes? I think that is a very easy question. To my Democratic colleagues, you've denied her your vote. I regret that. But in the process of participating in the hearing, you pushed her hard, but you didn't go too far. For that, I do very much appreciate that part of the hearing. So we will go to the floor now. We'll take up the nomination of Judge Barrett on the floor of the United States Senate. I doubt if a single Democrat will vote for her. And I'll end with this. Elections do have consequences. I understood that Justice Kagan and Sotomayor would be the type judges that a Democratic president would be looking at. Highly qualified, of a philosophy closer to President Obama's than mine, and that's why I voted for both of them. Now we find ourselves in a situation where qualifications no longer matter. It's about holding open seats to have them filled after the next election. And we've lost sight that the individuals being nominated matter. I think they do matter. So I just want to, again, compliment President Trump for sending to the Senate this outstanding nominee, incredibly well qualified in every way you'd want to judge. And I don't know what the future holds for the Senate. I know there's an election around the corner, and a word of warning. The Democratic Party of 2020 is hell-bent on changing all the rules. There won't be 9 members of the court if they get the House, the Senate, and the White House. There'll be at least 13. The legislative filibuster will fall like the judicial requirement of 60 votes has fallen. D.C. will become a state. The Affordable Care Act will be replaced by some more aggressive form of socialized medicine. But that's for the ballot box. Today was a process that's been in place for a couple of 100 years. Advise and consent. So I am proud to have supported Judge Barrett. I think the people of South Carolina would be very happy with somebody like her sitting on the court judging us all. So the role of advise and consent has been around for a couple 100 years. The last couple of 3 decades is taking a sinister turn. But I would imagine that our founding fathers would probably be proud of the fact that a woman is on the court. Probably not possible when it first started as a nation. We have changed as a nation, I think, moving in the right direction. But the thing I like about Judge Barrett is that the Constitution was a document written and the words matter. And change comes when the people of the United States have a say about change, not 5 people. The most important thing we have done today is we've ensured that in the future, with Judge Barrett, that the societal changes that people hope and dream about are not excluded. She will redirect them to the process that the founders had in mind, the people making the change, not 5 justices of the Supreme Court. With that, we will conclude the nominating process of Judge Barrett, and I will end where I began. The committee did the right thing.